Do you want to introduce yourself, Danny?
Yeah, my name is Danny Villazon. I'm an attorney. I've been practicing, appearing before the Florida Real Estate Commission since 1994, and I served as the Real Estate Commission's legal counsel for many, many years prior to going into private practice. The bulk of my practice is representing realtors before the Florida Real Estate Commission and the local boards, doing arbitration hearings when there's commission disputes and ethics hearings. What I'm going to try to do today is give you a little background of what FREC is looking for and what you need to have in your file and common violations that people are getting their licenses suspended or revoked for at the Florida Real Estate Commission. I also have an interesting case in regard to property management and criminal histories. And then I want to talk about two significant cases I've had in the last couple months regarding procuring cause that involved commissions of $67,500 and $55,000, where I represented the agent and there was another broker trying to take their commission, and we claimed we were the procuring cause and went to a formal hearing at the local board of Miami, and my clients were awarded those commissions. So I'm going to start off first with the FREC stuff. And if any time during the presentation, if you have any questions, just let me know, because I don't want to just talk for an hour straight.
Okay, can I just say something? I've actually muted everyone so we don't get any background noise. So if you want to speak, please unmute yourself. I'm done.
Okay. All right. Let me just give you a couple numbers there. There's about 400,000 real estate licensees in Florida, which is an incredible amount. Of those 400, only about 200 are active and working. One of the things that gets people into trouble is not keeping clean files. And you can keep your files electronically. You don't have to have hard copies. But the rule that requires FREC, that allows FREC to inspect your files, basically says that you have to maintain in your file documentation to show that you're in compliance with FREC rules and procedures and statutes. So it's very important that you keep certain things in your file. One of the main things they're looking for recently, and let me talk about what should be in the sales file. Always need a fully executed copy of the contract. That's pretty easy nowadays, but in the old days with faxes, people just used to fax the first page and last page. The thing that FREC is checking the most is the escrow verification letter. And basically what that is, do you guys use a title company when closing?
Yes.
Okay. You're required, if you wrote the contract, to list the name of the title company and obtain a copy of the escrow verification letter, and have that escrow verification letter in your file and provide it to the listing agent or seller if there isn't a listing agent within 10 business days. That is the number one thing that FREC is looking for when they're reviewing files, to make sure that that escrow verification letter has been complied with. Another issue that comes up is if you have inspection reports, termite inspections, you have to have some kind of documentation that you presented that to the buyer. So in case someone claims that they never got the inspection report or they never got the termite report, that you have documentation through email, which I like, with an attachment of the inspection report and termite report. Do not assume that the vendor gave it to the buyer. If you have a copy, it's your obligation to make sure that the other party gets a copy. So I'd be very careful with that, because I've seen quite a few cases where that's become an issue.
Can I ask a question?
Yeah.
What if the buyer orders these things themselves?
You don't have possession of it?
Yeah.
That's fine. You don't have to disclose it if you don't have possession.
If I didn't order it, I normally wouldn't get it.
Right. So the buyer, you don't have to worry about it. You only have to disclose things that you have in possession of and that you have knowledge of. That's the Johnson versus Davis. Disclosing all known facts that materially affect the value of the residential property are not readily observable. So it's important that you comply with that. I've had cases where somebody got a report that the AC wasn't working. They never physically handed it to the buyer. They said they left it on the counter when the buyer was walking through the house. And ultimately, of course, the air conditioning didn't work and the buyer made a claim and she had to buy a new AC or face charges of failing to disclose that she knew that there was a report that reflected that the AC wasn't working properly. And basically, that's what you need in your sales file. In regard to the listing files, what they're looking for is they want a fully executed copy of the listing contract, which basically means it has to have your signature and the seller's signature, and you have to have proof that you gave it to the seller within 24 hours. If you're using the Florida Realtor form, which I believe you are, there's a little box on the bottom that says provided to seller by email, fax, hand delivery. Make sure you check out that box and make sure that your seller gets a copy of the fully executed contract. That's all. And then also there needs to be a definite expiration date. Another important note, because I've had this happen, is make sure who you have signing the list. You have everyone who's on title on that property signing the listing agreement. Because I've seen some situations where there's a divorce, husband signs but wife doesn't sign. You procure a buyer, wife won't close. So for your own interest, it's best to make sure you have everyone that's entitled to the property sign that contract. And usually what I suggest is just go to the property appraiser's office, see who's listed as the owners, and make sure that each owner signs that contract, that listing contract, to protect yourselves, make sure you can have a successful closing. As far as all files, you should keep, I always recommend emails and keep those emails forever because that's the best way to protect you in many, many different things, including arbitration hearings, ethics hearings, FREC hearings, when you have emails to document that you send certain documents, that you sent to inspection and things of that nature. So I would recommend keep doing everything by email. I've seen a lot of people doing things by text, and I've gone to many hearings where people present their text messages. It's not as effective as emails. I found emails to be a lot more effective because you really can't decipher what a text says sometimes. Always the more documentation, the better. And make sure the email server you're using keeps the documents forever, because some tend to, after a certain period of time, erase emails. And my position is always the more documentation, the better. And now that you can store things electronically with no problem, you should have plenty of documentation to support your case for two things. One, if there's a FREC case, and two, more importantly, if there's an arbitration case where someone's claiming they're the procuring cause and saying you're not, and trying to take your commission. These emails can be very helpful in those hearings. Another issue they've been looking to is to make sure that your license is current, active, and valid. And basically, it's very easy to check at myfloridalicense.com to make sure your license is inactive. It can go inactive without your knowledge. It can go inactive if you fail to pay your renewal fee. It can go inactive if you fail to do your continuing education. And it can go inactive if your broker goes inactive. So it's very important that you keep track of your license. And the big issue here is that if your license is inactive and you procured a buyer, that listing agent can claim that you didn't have an active license, so therefore he doesn't have to pay you a commission. Because under Florida law, all contracts are void when dealing with someone with an inactive license, offers of compensation. So I've seen people being so busy fail to send their renewal fee, their license became involuntary inactive. They had no clue that their license was involuntary inactive, procured a bunch of buyers, and the listing agent checked, found out that they had an inactive license and refused to pay them the commission. And they lost the commission because the listing agent was within their right to not pay a commission to someone who was inactive. So it's your livelihood. It's very important to keep that license active and to make sure it's in good status. And because they don't send you a letter saying your license has become involuntary and active, it just happens. So you need to be careful with that. I don't like these cases, but it's the most common FREC violation right now. A couple years ago, they passed a statute that even if you pled guilty to a misdemeanor such as DUI, reckless driving, you're required to notify FREC within 30 days. A lot of people don't know that the law had changed, because prior to that, it was just felonies you had to report. So what's happening is a lot of people didn't know they had to report misdemeanors. Either a competitor, ex-wife, ex-husband, boyfriend, girlfriend knows that they had a DUI a couple years ago and are reporting them to FREC. And FREC is opening cases against those people for failing to timely notify FREC of the criminal self-disclosure form of pleading guilty to a misdemeanor offense. And the possible penalty is a $250 fine to a $1,000 fine, suspension to revocation. So we've had, unfortunately, a lot of those cases recently, and that seems to be what they're most focused on. Escrow account issues, you guys really don't have to worry about that. Since you don't hold escrow, you use title companies. Is that correct, Ben?
Yes, that's correct.
Okay. In the rule in regard to using a title company or attorney, where you have to get the escrow verification letter, is 61J2 14.008. And again, the key here is that you have to get within 10 days the escrow verification letter to the listing or seller. That also includes additional deposits. If there's an additional deposit required on the contract, you need to get an escrow verification letter for that too, and make sure that the buyer is in compliance with making the additional deposit. And you need to notify the listing agent whether they did or not. So it's very important that you keep on top of timelines in regard to escrow deposits. One of the things, I don't know how much property management you do, but a lot of people do not understand that rent is considered escrow money. And if you collect rent from a tenant, it has to go through your broker and through an escrow account. I always recommend, if you can get away with it, is have the rent paid directly to the landlord, but then it's a hard time collecting your commission if they get all the rent. But if you do receive rent from a tenant, it has to go to your broker within one. It's treated like any other escrow money. It is escrow money. Same with the security deposits. And you'd be surprised of how many people do not realize that rent is escrow money that has to be treated like any other escrow funds. We may be seeing these again. I don't know in today's climate. A lot of short sale complaints. They may be coming back. A lot of those cases involve listing agents not presenting all offers to the seller. We had a lot of investors complaining, indicating that they made an offer on the property and they never got a response from the seller, or the seller wound up selling it for less than the investor was offering. And what is happening there is a lot of listing agents had third-party contacts where they were probably in business with, and with a short sale, the seller really doesn't care what the price is, and they were buying these properties as investment properties and not presenting all offers to the seller. So that is a big issue. And the way you protect yourself from that is you maintain a copy of all offers you presented. Hopefully you can even get the seller to indicate that they're rejecting the offer. But it's your obligation, if FREC were to come in there and say, we have a complaint that you didn't present all offers to the seller, you have to be able to prove somehow, and usually with the contract signed by the seller rejecting the offer, proof that you presented all offers to the seller, because that is one of your duties as a transaction broker, is to present all offers to the seller unless instructed in writing otherwise. Okay? So we need to make sure that. I would keep, a lot of people do not keep all offers to purchase in the file because they figure the deal is done, it didn't go through, and they throw away that file. You need to have that in your file. Another issue that may be coming up is mortgage fraud. You need to be careful with that. I've seen lots of people get themselves in trouble And the least of your worries will be DPR if there's mortgage fraud, because a lot of times the FBI gets involved. Usually these were with incentives not disclosed on the HUD. That was a big thing in 2008, 2009, with all these condo conversions. They were offering all kinds of incentives, furniture allowances and things like that to the buyers, and they were not disclosed on the HUD. And ultimately the brokers were held responsible for not putting that on the HUD, showing that money was being paid outside of closing. Advertising, there's new advertising rules in regard to team advertising. Ben, do you guys do team advertising?
I think we have one team that does it, right?
Okay. There's a whole set of rules that requires you, one as the broker and two as the team, to make sure they're in compliance with the team advertising rules. And there's, let me see if I can pull it up. I had it a second ago. Yeah, it's Rule 61J2, 10.026. And it basically prohibits them from using certain terms in their team name. And two, it requires that whenever they're advertising, the name of their brokerage maximum needs to be in their advertising. And it charges the broker responsible for making sure they're in compliance with the rules. So that's the new team advertising rule, which is something they're really cracking down on. They're making sure that everyone that advertises the team is in compliance, because what you had was a lot of teams giving the impression that they were a different real estate company, that they had nothing to do with the brokerage. And so when someone would look up the team's name on myfloridalicense.com to verify their license, there was no license number. And that was a big issue. Another issue that came up, and Keller Williams is notorious for this, they love team names. And what was happening was some of these team names were incorporating as LLCs, and the broker was paying these LLCs commission. The broker cannot do that because that LLC, that team name LLC, is not a licensed entity. And the broker can only pay a licensee a commission. So you need to be very careful in who you're paying commissions to and how you're incorporating. I know a lot of people want to incorporate because there's tax advantages to that. But if you're a sales associate or broker associate, the only way to incorporate is in your name, the name that appears on your license. That's the only way they'll let you do it. And FREC will issue a license that says James Smith, LLC. Referral fees. The bottom line is that you can only pay referral fees to licensed people. If they're out of state, they need to make sure that they didn't conduct any real estate activities within the state of Florida. They can go with you to showings and things like that, but a buyer can't go with an out-of-state licensee and then you get a referral fee. It's very important that they conduct no real estate license services in the state of Florida. Unlicensed assistants, if you use them, there's a whole list. And at the end of this, I'll send Ben a PowerPoint presentation that has these things on it and has the activities that an unlicensed assistant can do. Dual employment. I don't know why this was a big issue back in 2007, 2008, because of the economic, a lot of licensees were getting second jobs. There's no problem with you getting a second job, but it can't be real estate related. It can't involve your real estate license. You can only work for one broker. So a lot of licensees thought they can go sit at a builder's house on the weekends working for the builder. You can't do that. It all has to go through your broker. So you need to be careful. If you do that, you get permission from your broker and you're sitting on the behalf of the broker, and the commission, if you get any, goes to the broker. You can't have a separate job with one of the builders and have your license with a broker. Okay, let me talk a little bit about the two procuring cases I had, which involved significant commissions. And in both these cases, my clients were represented, so-called, claimed to have represented the buyer. And what was happening was the listing agent was trying to take over and say they basically get both sides of the commission. In my first case, we're talking about a commission of $67,500 just for the cooperating broker on the buyer side. And what happened is my client was friends with the buyers. The buyer was an attorney. She also had a real estate license, and they were interested in some very expensive property in Coconut Grove, Florida. They didn't have access to the MLS, even though she was a licensee, she wasn't a realtor member. So basically they asked my client to make the arrangements to go see a particular property that was listed. And she arranged it, and she took them to see the property. And they met with the listing agent at the property. While at the property, the listing agent said something to the effect, you know, it's better for me if well, what he did was he said that he had another buyer that was using him that was interested in purchasing the property. That, you know, they were looking at the property also. And he also said, you know, it's better for me if this buyer buys the property, basically saying it's better for me if I give both sides of the commission. Apparently, the buyers in this case freaked out when they heard that, because they really wanted the property, and they had a feeling that the only way they can get the property is to deal with the listing agent. So they basically froze out my client, basically contacted the listing agent on their own, didn't keep my client in the loop, even though she sent them numerous emails asking, you know, what's going on, what's happening. It was very unfortunate because they were friends. That friendship was lost. And ultimately, they wound up purchasing the property with the listing agent and froze out my client. And usually in those cases, the buyer gets some kind of benefit by using the listing agent, maybe a rebate on the commission, maybe a lower sales price. But in this case, that wasn't the case. The listing agent got the full commission of $35,000. My client said she found out what happened, and she put in a claim for arbitration, claiming she was the procuring cause. And at the hearing, the buyers actually testified against my client and basically said we didn't want to use her services. We didn't feel she was competent. We didn't think she can get the deal done. And therefore, as buyers, we have the right to choose who we want to use. And we didn't want to use her. We want to use the listing agent. And your client's not entitled to any commission. Well, I can tell you these arbitration panels could care less what the buyer says. A lot of them call it buyers acting badly. And that is not the key in making the decision of who the procuring cause is. There are certain factors that the arbitration panels need to look at. And this is why I emphasize that you have to have documentation to prove you're the procuring cause. One of the first things they look at, but not the only thing, is who introduced the buyer to the property. And after introduction, it's not just showing the buyer the property and walking away and I'm done for the day. Did you make any subsequent efforts with that buyer to get a contract done, to get them to purchase the property? They also look to see what your conduct was, whether you were what they call estrangement, whether your behavior in the transaction, not returning phone calls, not getting the buyer information they need, maybe putting too much pressure on the buyer to buy the property, not representing their best interests, things like that, that cause the buyer and you to have an estranged relationship. And therefore, the buyer went to another broker. There's also another factor they consider, it's called abandonment. Again, you need documentation to show that once you introduce that buyer to the property, you continued working with that buyer, you continued to service them, answering their questions regarding the property and things like that, that you didn't abandon them. And those are the reasons why I like lots of documentation with emails showing that you sent the buyer comparable sales, you sent the buyer inspection reports, you sent the buyer title information, inspection, just documentation to show that you were working with this buyer, that you had contact with this buyer, and that you didn't abandon them. Then they also look to the conduct of the listing agent, of the other agent, or the second person who's claiming to be procuring cause. They're looking to see if there was an intrusion in your relationship. And in this particular case, I was able to show the intrusion. I was able to show that the listing agent scared the heck out of the buyers by making that unethical statement that it would be better if he had both sides of the transaction. And basically what the panel found was that the buyer in this particular transaction was freezing out my client, the original cooperating broker, in order to please the listing agent in order to get the property. Ultimately, what happened was the arbitration panel found that my client was the procuring cause because she introduced the buyers to the property. She did not abandon them because she had extensive documentation where she continued to email them and contact them about the property. There's no evidence that there was an estranged relationship. And the only thing that caused my client not to be the cooperating broker was the actions of the listing agent by not calling my client when those buyers presented to him. His obligation was once the buyers, the buyer's represented by another broker, and that broker comes, and you're the listing agent, and that buyer comes to you asking about the property. You have an obligation to call, unless they tell you don't call. The other saying your client's coming by, I know you showed them the property, what's going on here? Sometimes they'll tell you, we simply don't like this person anymore. She did this, this, and this, and then you can maybe represent them. But you need to have some documentation that you made efforts to reach out to the buyer's agent and make sure that truly that the relationship has been estranged or abandoned. Because if you don't, you'll be looking at a procuring cause issue. Well, ultimately, like I said, we were able to show that it was the buyers who behaved badly. My client didn't do anything wrong. She tried as hard as she could to continue to be the agent, but the buyers were spooked because of the listing agent's words. And my client ultimately, after a long drawn-out hearing, was awarded the procuring cause issue. In the second case I had, it's kind of like the same situation.
Who had to pay your fees?
Well, unfortunately, attorney's fees are not included in the arbitration. What I did with this particular client, we did it on a contingency basis. I got a percentage of her commission if we won the case.
Thank you.
But just so you know, attorney's fees are not included in arbitration hearings. They can't award attorney's fees. They can only earn the commission. In the second case, it's the same thing. I did it on a contingency. It involved a commission of $55,000. And again, my client was working with these buyers left and right, has it documented every time he took them to the showing, has it documented all the MLS showings he provided them. It's a very tragic story because his wife was very sick. She was terminally ill with cancer. And despite that, he was still taking these buyers, showing them property. And he showed them a property right next to another property that was for sale. And he showed them the first property, which was less than the property across the street, because the buyers wanted him to show the lower price property. He told them about the property across the street. He said, I'll be happy to show you this, but the price is a little bit high. It's not within your bargain. And they said, okay, no, we don't want to see it. So he knew about the property. He told them about the property, but they had expressed to him that they weren't interested in the property. Well, ultimately, after months and months of showing them the property, they went back to that property that they didn't want to see. And they talked to the listing agent directly. And the listing agent gave the impression that if they worked with her, they can probably get the seller to reduce the price. So they basically cut out my client. They continued to use him to show other properties, continued to ask him about properties. His wife ultimately passed away, and a day later, he was still showing them properties. And they didn't tell him that they went under contract with the property with the listing agent. And ultimately, they just ignored him. And he ultimately found out, looking around, saw in the MLS that that property is sold. And he found out that the listing agent got both sides of the commission. So again, we went to arbitration. And again, we were able to prove through emails, numerous emails and documentation, that my client did everything for these buyers, had sent them the MLS information about the property in question, had shown the buyers all kinds of properties, was working with the buyers on other matters, even when they entered into a contract to buy that property with the listing agent. We were also able, and again, the buyer testified and was trying to help the listing agent keep the commission, and saying they didn't want to use my client. They really didn't have any excuse for not using my client. They just said they didn't want to use my client. But I was able to get the buyer to admit that the only reason he used the listing agent was so he can get a lower price. And we got the listing agent to admit that she reduced her commission so the buyer could get the price that he needed to get to, and basically froze out my client. Again, we have extensive documentation showing all the efforts my client made, how many offers. He even had offers on other properties that he made on behalf of these buyers that didn't go through. The arbitration panel, again, awarded the $55,000 commission to my client. What's interesting here is the broker didn't collect the full commission because the broker waived her percentage of the commission on the cooperating broker side in order to get the deal done. But regardless of that, they are still on the hook for the $55,000, even though they didn't collect it because they unilaterally waived that cooperating side commission. They have to pay my client the $55,000, which we haven't got yet, but we should be getting after this coronavirus thing is over and the appeal time periods are run. So I can't stress how important it is to keep documentation in your files to show the interaction you had with the buyer in these type of things, to show that you contacted, if you're the listing agent, if you're on the other side, that you contacted the cooperating broker and explained that the buyer was coming to you. Because I can tell you the arbitration panels are very concerned with the failure to cooperate. And that is a huge issue in the real estate industry, at least down in South Florida, is this idea that they're not going to cooperate with other brokers, that they're going to get the entire commission. So you need to be really careful with that. Another case that, go ahead.
Sorry, I just had a quick question about commissions because we recently encountered it, and I know I sent it to Bent too because I was mind blown over the guy's response, because I never look at the commission because you're just assuming it's at least 2%, I guess,
Right.
going to you. Like, you just assume, right? So if it's in the MLS, I'm just sending it out. I sent my clients a home. They do have interest in it. They would like to see it. And I'm like scrolling down to contact the agent, and it says the co-broke is $1. So I email him and I'm like, hey, I'm just assuming that this is a typo because it's $1.
Right.
I was like, so can you confirm what the commission is, the co-broke? And he goes, yeah, that's correct.
Well, because of antitrust rules, there's no set commission. Now, I highly doubt that his client understands what he's doing.
Yeah.
And I think it's definitely not looking in your client's best interest when you're only offering $1, because nobody's going to show that property for $1 or take the time and effort. So there's nothing you can do about the commission because there's no set commission rate. That would be antitrust violation. However, I think there could be a FREC complaint against him for failure to look out after the best interest of his seller by doing that. Because I can't imagine that the seller understands exactly what he did in that situation, because truly he is limiting the marketability of the property.
Yeah, if you're going to take a hit on commission, we say, take it yourself, obviously, but still co-broke out at least 2.5%.
Right.
So I looked through to see his other listings, and he has other listings that are the exact same way, offering $1.
Yeah. He's definitely tricking the sellers in these particular transactions. I'm not sure how he's selling these properties because no one is probably showing them. So
no, he's had one of them listed since October.
Yeah, so he's really doing his clients a disservice. The only thing I can think of is the seller can file a complaint with FREC because I really think he's acting dishonestly and not acting in the best interest of his buyers.
Yeah.
Of his sellers, I'm sorry. So that's an issue.
Who can tell the seller? I guess we can't just go to the seller.
You can file an anonymous complaint with FREC and just say, look at this. I'm not sure the seller is aware, and they may send an investigator to talk to the seller and see if they're aware of that. But yeah, you can't talk to the seller because then you'd be in violation of the code of ethics.
Right. So they've been listed since October. The home's vacant, so I'm sure they need to sell it. It's in an
Yeah.
HOA, so they're paying HOA fees. They're paying taxes on it. Listed since October. I mean, people are still buying right now, so I'm going to assume it's because no one's showing it.
Yeah, that definitely no one showed it. No one. Well, it's crazy. Why would someone show that property for $1?
Yeah.
Yeah.
Out of curiosity, are they the broker or do they have a broker?
I'm not sure.
I just wonder if a broker would call a broker and just say, do you know what your agent's doing? Have you reviewed it?
True.
Yeah.
You should do that, Ben.
More than happy to.
Yeah. Ask the broker. Are you sure? You know.
Did I
It just
volunteer
seems-
you, Ben? I'm sorry.
Yeah. No. It just seems a fruitile. What's the point? If you never sell the property, you're never going to get a commission. So why are you wasting time?
Yeah, and I feel bad because I know my buyers want to see it, but I just told them, I was like, hey, full disclosure, I'm not making any money on this. So,
Well, that's what he's hoping for. I think he's hoping for a buyer to contact him directly.
yeah, of course. Yeah.
Another interesting case I had, this involves the Fair Housing Act. It's really crazy. It was kind of scary when my client called me about it. There's a Supreme Court decision that talks about disparate impact. I don't know if I'm pronouncing that right, but basically in a nutshell, what they say is people who have criminal histories are more likely to be minorities. That's been the studies, and most people in jail are minorities and things of that nature. So what is happening is that some property management and some owners are saying, we don't want people with a criminal history to rent our properties. And what is happening is there's this group of people, this law firm, that goes around calling landlords, disclosing that their tenant has a criminal history, driving without a valid license 3 times, which is a felony. And is that going to affect them renting the property with their criminal history? And what happened in this case, someone called, my client had indicated that the owners don't want a criminal history, someone with a criminal history in the property. They're on probation or something like that. I can understand it. Someone called and asked whether he would be able to rent the property because he had a felony for driving while license suspended 3 times. My client really didn't respond. She said, I'd have to check with the owner and things like that. And what ultimately happened was my client, the broker, got sued with the anti-discrimination charge because they said they were discriminating against people with criminal histories, and this disparate case under the Florida Supreme Court, under the U.S. Supreme Court said that's discrimination by inquiring in someone's criminal history and not renting to somebody with a criminal history. Ultimately, I think that I didn't represent him on the HUD complaint, but ultimately it got resolved. But the bottom line here is, and I'll send Ben this memo, you need to be careful when renting property and talking about criminal history. You have to have strict policies in regard to what you're asking for when you're looking for criminal histories. And the NAR wrote a paper on the best practices and policies when dealing with that issue. I found it a fascinating issue, and the fact that there's these people out there who make a living going around calling, ads for rental properties to see if people are violating the HUD requirements. So if you're doing property management, you need to be really careful of that. And Ben, remind me to send you this article.
Well,
Or to criminal history based practices and policies by the National Association's Realtors Legal Affairs Department. And there's a law firm down in South Florida that's all they do. They troll these different websites to find it, and then they hit you with a lawsuit, and then they ask for some incredible amounts of money to try to sell it with you. Let me go back to my PowerPoint.
we're used to that.
Yeah, I know. You were one of them. But not on that issue. That was a different issue.
Yeah.
If you do get a FREC complaint, there's things you can do. First, you need to notify your broker, because they don't notify your broker if there's a FREC complaint. You need to notify your broker so we can put up a defense. You basically have a couple options. You can fight it, you can admit to it and take the penalty, or you can do nothing and ultimately probably wind up with your license suspended. There's a certain types of violations that are considered minor violations that can be resolved with the citation. Unfortunately, that citation is a public record. So when people look up your license number, they can find out that you've had a citation issued against you. And I can assure you your competition will use it against you. There's also a way to seal that after a certain period of time, but it has to be considered a minor violation. I don't know if you want me to go into all the formal complaint process and all those things, because hopefully you guys never have a violation. Another thing the FREC is really looking at recently is to make sure that you have your proper address registered with FREC. And that is, they define your address as your home address. So you need to have that on record with FREC, because if they ever serve you any documents and it goes to an address and you don't get the mail there, they're going to hold you responsible. And I've seen people get their licenses revoked as a result. Of that. Let me see something. Here's a topic I call helpful risk reduction tips. This was a list of things I received from an E&O insurance carrier. It talks about things that, you know, their clients have gotten in trouble when claims have been made. It recommends always obtaining a written seller's disclosure. Never fill it out for the seller. Always have the seller fill it out. Never go on an inspection without your buyer, because they'll blame you if anything goes wrong. And on the seller's disclosure, that's obvious. You don't know the property. So you have to have the seller do it. Don't do it for the seller. Never act outside the scope of your expertise. You're there to market the property or find the property. I've seen people get into trouble by giving zoning opinions and things of that nature when it wasn't zoned for it. You can't have a daycare in the house and things of that. So you need to be careful on what you give people advice on, you know, 1099 information, investment opportunities and things like that. Tax issues, you refer them to an accountant or you refer them to an attorney. Just don't act outside the scope of your expertise. Follow pre-established office procedures. Disclose all conflicts in writing. And there's a case with FREC where if you have a familiar relationship with one of the principals, you need to disclose that. For example, if your daughter is the buyer, you need to tell the listing agent that your daughter's the buyer. Familiarize yourself with the fair housing law. I'll go into that in a little bit. I got to find my tab on that. If you're not sure of something, always ask. Bent knows where to find me if there's any ever issues. He's got my phone number 24/7, and better to ask a question than get yourself in trouble. Know the code of ethics, because that's there to help you. And if you follow those, you shouldn't have any issues. I had some stuff on fair housing. Let me see if I can find it. Give me a minute. Ben had asked me to talk about fair housing a little bit, but I don't know I did my slide. So give me 2 seconds.
And you had the list of stuff that you said. Did you say not to go on an inspection without the buyer?
Yes.
How does that work when we have so many out-of-state buyers? Like I literally have worked with buyers that sometimes weren't even in the state during the transaction.
You do the inspection for them?
Like I let the inspector in, and then in another case, like they weren't in town to do the walkthrough, so we did a video walkthrough. Does that still count as the?
Yeah, I think a video. I was about to say a video walkthrough, because you have to remember the liability and the exposure if something was wrong. Okay.
Mm-hmm. Yeah.
And now they're going to want someone to blame, and they're going to blame you because you did the walkthrough. And the inspector's going to say, well, I pointed that out. She never told me. You know, the buyer's going to say, you never told us that the inspector said this was something wrong, and it can get you in trouble. If you could avoid it, avoid doing the inspection on your own. The videotaping is good. I think that helps you. letting the inspector in without you walking around with him or her, I think is okay too. But you need to be careful because you don't want to increase your liability if something does go wrong, because it's not your responsibility to make sure that you report everything the inspector said to the buyer and things of that nature. You're increasing your liability if something goes wrong by doing that.
That's something we've always said, Shannon. We've always tried to push so that you're never supposed to be there without the clients present. Like we always we open the door for the inspector, but we don't ever stick around because of that liability. That Jay's actually stressed that to us a lot.
I'm sorry, I went away. I don't know what happened to my internet connection. I didn't get any of the last minute and a half.
Oh no. You need Danny to talk more?
Okay, you want to talk again?
I'm so sorry. I was like, where did my internet
Yeah,
connection
I know. I
go?
saw that you froze up. I
Everything
wasn't sure. I wasn't sure I was talking to myself. Yeah, you need to be careful with that. I understand your situation, but you're exposing yourself to more liability if, for example, the inspector pointed something out, you didn't relay that to the buyer, that turns out to be a major problem. The buyer's going to say it's your fault because you didn't tell us. So the videotaping, I think, is a good idea. Letting the inspector inside the house, but can you hear me?
Yeah, I can hear you.
Letting the inspector in the house without you going in with him or her is okay too. You just need to be careful when you're doing it. You're taking on that responsibility that you're going to report everything correctly and what the inspector said to the buyers. Because if something goes wrong, I can assure you they're going to come after you. Okay?
Okay.
All right. Fair housing issues. These are just some things I've obtained over the years from other people who specialize in fair housing issues. I don't, but they stress avoid using words and phrases in a discriminatory context in conversations or advertising. Never work with a discriminatory buyer or seller, tenant, or landlord. If someone tells you, we don't want to rent to African Americans, you tell them I can't do that, and you don't want to work with that person. And you need to be careful in the advertising. And just remember, equal service to all. I have a list of words, and it's really tiny. I'm trying to enlarge it. And I'll send it to Ben that talks about certain words that shouldn't be in advertising. And I'll send this list to Ben. I got it from, I think, from the National Association of Realtors on words to avoid using in advertising in fair housing situations. That's all basically what I have. I don't know if you want me to go into details of what a FREC inspection entails and all that, but those are just some things I try to highlight in order to avoid having the FREC inspection. Does anyone have any questions?
Remember to unmute yourself if you speak. Oh, I can unmute all. No questions?
Okay.
This is
Yeah,
very informative, and I really, really appreciate it.
Okay, Ben, I'll send you this PowerPoint that has the words to avoid and has all that stuff, and I'll send you the memo regarding criminal histories.
Yes. And do you still have a, did you say you were going to send us the slideshow that you normally use?
Yeah, that's the PowerPoint.
Yeah, the PowerPoint, yeah.
Yeah.
Has it changed since last year? Because if it hasn't, we still have it.
Not really, but I don't know if I had the words to avoid using in the Fair Housing Act amendments.
So we'll take
I'll just send you what I have. If it's duplicate, just.
And also, I think the thing about what you can and cannot do with team names, I think we need that reviewed too.
I'll send you that rule.
Yeah. Thank you.
Okay. Especially since the broker is responsible.
Yes.
All right. Thank you, everyone. Have a good day.
Thank you.
Bye.